So here we are in my home studio again for the trial preparation week 2, and I plan to cover 3 topics. One is related to an assignment that you have, the trial countdown calendar. The second is research on your jury venire. We'll talk about then focus groups as a means of trial preparation. I find them to be very important in important cases. It's a expense and it's a time commitment, but if it is a case where you have the possibility of recovering a lot of money if you're successful, or in criminal cases, if you're dealing with substantial issues of a life sentence, or in capital cases, life or death considerations, they're very helpful. So first, let's talk about the trial countdown calendar. There's an assignment related to this in this week's material, and I have put in there a go-by, if you will, a model for how I have done it in the past, how I've set it up. The entries are missing because that's part of your tasking, is to look at potential entries for that calendar, and the purpose of it is to make a systematic, a pre-thought out plan about how to be ready as the trial day approaches. I've generally used a 90-day countdown method where the content in the calendar goes from day 90 down to day 1, which would be the actual day of the trial beginning. And so that's how I've chosen to do it, such that over the course of 90 days, 3 months, I can note the progress of how preparation is coming, with day 1 essentially being the day before trial. That's when your preparation obviously ends, and it would end on that day before trial. Perhaps that's a Friday for paralegals, perhaps a Saturday work day. If I have a Monday trial, I'm there on Sunday doing some work. But for the paralegal, obviously that's the day where you pack the bags. That is, you are putting pens, paper, pads, post-it notes, breath mints, you name it, power cords, chargers, that sort of thing in the bag that the lawyers are going to take to trial. In all likelihood, that would be a rolling cart of some kind. Backing up from that day, that last day, is the considerations of what sort of packaging are you going to need. Banker's boxes, hard plastic boxes, that sort of thing about how we're going to get the file from the courthouse to the office, or vice versa, back and forth. One thing too I would consider is, what can you leave out? What are duplicates? What are things that will not be pertinent for that first day in court? So that'd be one of the things on your calendar, is talk to the lawyers about what they think they're going to need. If it's jury striking day, there may be all kinds of information they need about the jury venire, that sort of thing. But there may be motions that are argued on those days as well, motions in limine, which are simply pretrial motions about the admissibility of evidence. That is spelled motion in limine, I-N, next word, L-I-M-I-N-E. And it just is, there's some Latin in there somewhere about what admission of evidence, ruling, pretrial rulings about that sort of thing. Maybe motions to suppress. If you're talking about a criminal case, the sorts of motions that come down to the days before trial beginning. Obviously, if you are dealing with a non-jury case or a divorce case, day one is day one in terms of presenting evidence and having witnesses ready. So the file has to be, ready for the call your first witness announcement. Whereas jury trials, there may be a day, maybe two or more, depending on what kind of trial, is spent just simply striking the jury. Other things to think about with that countdown calendar going further backward is the technology assessment. I think we talked about that in last week's video, but getting a sense of what is available in the courtroom, and making sure that there's a time set up for a media run-through. By that I mean take the lawyer, who may be young or old, and adroit with technology or not, and do a run-through so that we know how things work, or if they don't work, and just where the screens might be. If they're affixed to the wall, you can't move them. Just how your setup might be for, say, an opening statement in a case. So just going back to other things that paralegals might do is summarizing discovery, indexing discovery, if there are depositions, summarizing them. If there are medical records, tabbing the essential portions of medical records, and perhaps copying those exhibits. You would admit perhaps the entirety of a medical record, maybe a stack of paper, but as far as what you're going to hand to a witness and ask them to look at and explain or acknowledges the authenticity of, or whatever, or acknowledge statements that were made within those records. With respect to that, you're going to have a few sheets of paper, ideally, 30 of the 300 sheets. So select those out, duplicate them, have them ready. And so going further back, there is something that, obviously the lawyers have to participate in, but the assessment of whether all the discovery is in your possession. If it's a civil case, have all the discovery answers been provided from the opposing party? In a criminal case, have things been done such that we know we have what the DA has? If it is a capital case, or you're in a jurisdiction where there's open file discovery, perhaps a sit down is in order. That needs to be scheduled, where essentially you take your file or your index. The lawyer would obviously, I think, be participating here. Perhaps an investigator would go also think about who would need to be involved in that meeting, and then passing that on to the lawyer, like, here's a date for you to compare your file. Or that's also, I think, important in civil cases, to do those kinds of things. That's probably something that should happen fairly early on in the process of getting ready for trial, so that if there's some discovery problem, like the plaintiff or the defendant refusing to answer or produce documents, or failing to supplement, if it's an ongoing issue, like if it's a personal injury case, the person's medical condition is important right up to the day of trial. If there's some claim of disability, or loss of earnings capacity, that kind of thing. In criminal cases, perhaps your own client's records are, need to be updated. If it's a capital case and you're dealing with mitigation, pardon me. If an issue is your client is well adjusted to being in custody, therefore no future dangerousness, good behavior while in custody, you need to update your records from the jail if they're in custody. So those sorts of things need to be looked at. What medical records might need to be subpoenaed. If you're a plaintiff and you're trying to establish damages or injuries or whatever, usually it's not by subpoena, but updating medical records by request or subpoena, or perhaps scheduling a medical consultation prior to trial. Generally, you need to also look at discovery cutoffs. I mean, there may be a situation where if you're in a civil case, all discovery has to be finished 90 days before trial or 60 days before trial. All this requires collaboration and thinking through what needs to be done and what is left to be done. Another thing that, from a paralegal's perspective, that you may drive the action on this is displays, demonstrative exhibits. That is, an exhibit that is meant to display information in a summary form, typically, that may have to do with, in a civil case, injuries, expenses mounting, lost income mounting, that sort of thing. Or in a criminal case, the crime scene, a weapon, or some whatever the issues are, could drive what needs to be put into a demonstrative exhibit, a PowerPoint presentation, for instance. I want to suggest also that some real time be put in thinking about what statements might be excerpted, or what might be put into a blow-up presentation, because often it's the statement of witnesses in civil and criminal cases that are very important, especially for a cross-examination or a closing argument or something like that. The other topics we're going to talk about need to be on the calendar also. When are you going to request the jury venire, that is the list of people summoned for jury duty? When might you schedule a focus group? That generally has to be done at some location remote from a lawyer's office, because there's generally not enough space, and it's generally not a good place from which to do focus groups, because the lawyer will be subject to interruptions in the normal ebb and flow of what goes on in the law office. I have used the conference room at the Decatur Entrepreneurial Center. They have some video capabilities so that the lawyers can view things remotely when, perhaps a mock jury deliberation is going on, that sort of thing. But anyway, so all the details of how those focus groups happen, how you get people to be participants and so on, we'll talk about that in a minute, but it must be calendared and somebody knows whose job it is to make sure it's done. And although the logistics may be a paralegal's responsibility to execute, it's obviously some lawyer's ultimate responsibility to make sure things are being done. And so that's why you have those columns where you might have lawyer one, lawyer two, and all that, whose job it is to, just because a particular task might be performed by a paralegal, it might need to have a lawyer's name indicated as also being responsible for consulting with the paralegal and looking in and making sure things are done. All right, so in putting together these countdown calendars, I would suggest that maybe you look online for some things that are out there that are like litigation checklists, trial preparation checklists. They're out there, and I think they are useful to look at. I've done that research myself, and I know those things exist to educate you about things that, for instance, if you haven't had the civil procedure or the criminal procedure class, just knowing what things there are to do for trial preparation purposes. So consult the internet about those kinds of issues. You can draw from the textbook, if you still have it, from that civil procedure class. But just the ordinary tasks that are involved with preparing for trial, those need to be thought through and scheduled for when to do those things so that things don't pile up, or the most, I guess, important thing is so that things that are important but not urgent get done, and the things that are urgent and important get tended to, and the things that are not urgent and not important, if there are such things in trial preparation, are, because of their lack of urgency, are nonetheless noted and tended to in a systematic way. I don't know if you know that lingo, that it's the four quadrant time allocation issue, that it's attributed to General Eisenhower, President Eisenhower, and then it's also used by the Stephen Covey books, like I think Time Matters was one of his books. Obviously, his most famous book is The 7 Habits of Highly Effective People, or something like that, where you have four quadrants: important and urgent, important, not urgent, unimportant but urgent, and then unimportant and not urgent. And you sort of look at what needs to be done in what order based on where things fall within that quadrant. But basically everything, if it's thought through and planned for, will get done, and there'll be no surprises about some big thing that's fallen through the crack. Or if there is nonetheless a surprise about something that's fallen through the crack. There won't be three of them, maybe just one of them. So that's why we plan systematically to get ready for a trial. All right, so I want to move on to focus groups. As we've talked about obliquely in the countdown calendar, these are meetings, events whereby you bring hopefully a representative group of people together to assist the lawyer in getting ready for trial by means of trying opening statements, trying themes and theories of defense if you're in a criminal case, or in a civil case, defense, or the plaintiff's case. What sorts of things are resonate with the jury? What things could be said better? And that's all very important, because lawyers, you know, they say in law school you're taught to think like a lawyer. Unfortunately, what that means is you cease to think like a person, and you get carried away with the way a lawyer may think about something, or you get carried away with your own cleverness, and you're setting yourself up for an argument or a theme that just has no resonance with the jury. The other thing is it's an opportunity to have a client practice, if you will, with a group of people who are mock jurors. Obviously, people who you represent, your clients, they're not in the courtroom frequently. And so it's a very unnerving situation, and they need some help getting comfortable. And sometimes one of the most daunting things is sitting in front of people and just having those eyes focused on them. You don't have to get into, say, a nitty-gritty part of the direct examination where some of your case strategy might be displayed in a less than airtight confidential setting, but just the practice of getting in front of people and doing introductory testimony, like, you know, tell us your name and where you're from, and where do you live, who lives there at the home with you, what kind of work do you do, where did you go to high school, etc. That practice can be valuable for your client. It may seem very routine to the lawyer, but it's helpful to the client. I would also say that it's a good opportunity to have witness statements, perhaps reviewed, a video if you have it, a written statement if you have it, a particular graphic that you're thinking about, a demonstrative exhibit, just having jurors react to that sort of thing. So the idea of a focus group is different from a mock jury where you're going to put a trial on from start to finish. Those stretch over many days. Those are very expensive. You obviously need, pardon me, you obviously need the whole shebang, a prosecutor or a defense attorney or plaintiff attorney on the other side, somebody who functions as a judge, and jurors, along with somebody who may be the director, so to speak, of the mock trial. The focus groups are, I mean, those things have their role, but focus groups are more focused just in terms of what you're doing, and they are, you can do more than one. If there is money to do more than one. Sometimes a jury focus group can be used to vet, big ideas and directions in the case, and then closer to trial, you have something that is more refined in terms of your presentation, and you're fine tuning at that point rather than just, I wonder how this would sound to a jury, or I wonder what they would think about such and such. All right, so I think that a focus group director is essential. So if those things are done, as a paralegal, you might find yourself working with him or her in terms of logistics and how they like things done. The issue of using one of those is it's more expense, but it also is a fresh set of eyes who's there in a professional capacity, not a friend capacity, and they will have the ability to read the jury as things are happening and maybe suggest, or read the participants of the focus group and maybe suggest certain things that should be worked on versus others. I think that focus group participants tend to discuss more readily with someone they perceive as a layperson, whether or not that person is a lawyer or not, but they're not the lawyers involved in the case. Even with hired focus group participants, they sometimes will have scruples about wanting to speak freely to the lawyers who are involved. They don't want to hurt their feelings or something. I don't know, but they'll talk more freely to a facilitator. Anyway, there are things that you can read about focus groups. It might be a career path for you after you are in the paralegal field for a period of time. So enough about that. There's an assignment about, reading a scenario and then suggesting questions that you think might be posed to a focus group as a way of testing the approach that may be best received by lay people, which is ultimately the deciders in jury trials. I don't think these are necessarily a lost cause for bench trials, for judge trials. Obviously, if you're focus grouping a bench trial, your focus group participants need to be retired judges or judges from other jurisdictions. I've not necessarily heard about that being done, but ultimately, what persuades juries is persuasive to judges, and it's generally whoever has the best story wins. And a lot of that's discovering what the story is, what the people like about your facts, your client, or what they don't like about your facts or your client, or even the lawyers. There are people who come off very genuinely, and then there are people who come off as know-it-alls and everything in between. I don't need to tell you that lawyers are a group suspected or subjected to a lot of suspicion. A variety of personalities get in this business. So anyway, let's move on to talking about Venire research. That word is Venire, and a Venire is simply the list of people or the collection of people who have been summoned for jury duty And we have the ability to look over that list of people ahead of time. And I want to suggest that it gives us an opportunity in the computer age, an enhanced opportunity to do some research about those people. Now, there's a fine line between research and jury tampering, which you do not want to do. But so you're not contacting potential jurors and doing a rundown on what they think about case issues. Do not do that. That would seem obvious to me, but maybe not to other people. What you're doing is typically checking public records. You're checking social media, and then simply, I think something that happens is very fruitful in a small, medium-sized jurisdiction like the one I practice in, or certainly in smaller communities, is circulate that list to people you know. Circulate that list to people who know a lot of people. Circulate portions of the list to people who know a lot of people. If you know somebody, for instance, if you're in Morgan County, a guy that runs a store out in Somerville, a guy that runs a business in Danville, I mean, they'll know the people in that part of the community. A great source is retired teachers or principals. Why? Because they know several generations of people in your community. People that go to large churches, the First Baptist, First Methodist, large non-denominational churches. You can find out things about people by just simply circulating that list of people and saying, do you know this person? And then once they say, yeah, I know that person, then you can dig deeper and perhaps get more comments. So I would say that a person's criminal history would be of interest. A person's the charities they seem to favor on social media, the political views they have. Are they pro-Second Amendment? And you're looking at a self-defense case. You need to know that. That's a big deal. If you're trying a police brutality case and a person is reacting to the current events that involve the death of people with the police seeming to be at fault, you need to know that. Are they pro or anti? Depending on what side you're on, you need to know those things. If there's police misconduct in your criminal case, there's another flag. Just look at what people will tell you about themselves on social media. It generally is fairly amazing what people will reveal about themselves. You want to look at things as mundane as if it's a criminal case, who have liked the DA's webpage, or who are Facebook friends, for instance, with the district attorney or with the judge. Judges are increasingly on social media as it's kind of an indispensable part of campaigning in public relations, which is pertinent for them, but certainly for the district attorney, because a lot of PR goes out on those pages, and it's just another means of looking at who might have social connections, because some of your Facebook friends are people you don't know. I mean, they're like my Facebook page has a lot of people that I don't know who they are. They are because my Facebook page is partially there for marketing. But some of the people are my neighbors. Some of the people I've known all my life. Some of the people I go to church with. And you never really know until you look about the closeness of the connection. So you mine all those sources, but the important thing is how do you put that information together in a usable way? Spreadsheets are the way I have found to be useful, and typically one that can be shared, like a Google document. And it, if you use a spreadsheet, it is can be sorted. It can be, people can be isolated based on what communities they live in and so on. So the way you would set up that spreadsheet is obviously what the person's name and their address, their age, their race. I would note that for purposes of you're just knowing, perhaps the the exercise of jury strikes. Are we looking like we have an issue of discriminatory use of peremptory jury strikes? So then I would put, perhaps political, comma, affiliations, comma, put a column like that, and then have a comment section where you have just whatever comments that you gather, whether it's the observations of a lawyer, observations of a paralegal, or whoever's doing this research. And then, if you get observations from community people that you circulate the list to, you put it all in one place and put the miscellaneous things in that comment section. That way, by the time you have you're ready for trial, you've got, rather than looking at a comment scribbled somewhere on somebody's paper version of the venire list, you're looking at one document. Now, one thing you want to be sure to do so you don't wear yourself out only to find out that someone has been excused from jury duty is leading up to the time of trial, get information from your clerk about who has been excused or deferred. Excused means they don't have to come, they're too sick or something. And more commonly, you have people who've been deferred. That is, they can't come this time because they have a surgery scheduled, but they're perfectly able-bodied at any other given time, and they'll come to a jury term of court in 6 months, perhaps. So people are either deferred off the current jury term or they are excused. Some people have moved away. Some people have died. Some people, they'll discover that they have a felony conviction, which is a disqualifying factor. You can't have a felony and serve on a jury. It's one of the civil rights that are lost upon a felony conviction. Those people, obviously, you don't put a lot of time into research. You don't put any time into researching them. So putting together the spreadsheet is the first thing you do. Just putting the names and all that on there, but getting to the actual expense of time and effort, that should come later in the process. Something to keep in mind for your trial countdown calendar, because a number of those people who are there on that list are going to be gone from jury service, and so maybe you check incrementally with people who maybe at the 2-week till trial time frame have gotten deferred or dismissed or excused from jury duty. Another thing you might do is closer in, check again just to be able to clean up your list. Maybe you checked it 2 weeks and you did all the research, but you can take them off the list if they're excused later in the process. So you take that document online with you to court, and you can edit it when you actually see who shows up. Because from a jury venire, you'll have people who are conscientious enough to seek deferments and seek excusals, and then you'll have people who just simply don't show up. All right, so you typically will take them off. Then you'll have people who come to jury duty but need, either they've had something come up suddenly, or they were told to come and report and then make their case to the judge about why they should be excused, in which case you will take them off then. That's why it needs to be an editable, computer document, Excel for instance, so that you can edit in real time. And you'll need someone there assisting the lawyers who can also be putting in comments and observations that are made during the jury selection process, during the jury questioning, or at other times when you make observations, like somebody they are, some activity or some behavior they're exhibiting needs to be noted for purposes of deciding what jurors you want to keep, which ones you want to get rid of. Also, time needs to be allocated after jury selection to gather all the notes of the people who've been participating and observing. At the end of the day, back at the office, put all those comments on the spreadsheet so that when you're doing the actual striking, the deselecting process for selecting a jury, you'll have all that information in one place and readily accessible, because sometimes you have the ability to consider the strikes very, very carefully and very systematically, and sometimes the judge gives you 10 minutes. So I think that coming to court on subsequent days of jury selection, you're going to need to have provisional strike lists, provisional ideas about who we want to get off the jury. But that's something you do, I think, in those after hours meetings, and then you are able to, if jury selection somehow finishes in the middle of a day and you don't have an overnight to prepare for selection, you'll have that information at your fingertips. So the calendar, research on the venire, and focus groups. If you have any questions about that kind of stuff, let me know. Be happy to trade emails with you, be happy to talk to you. If it hasn't come through, I like what I do and will be happy to share ideas with you about this stuff now or in the future. All right. See you later.